U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. And I have a really good topic for you today. So I'm going to talk about how to get the green card without marriage. So I will see this in the questions, and that is a very extensive topic. But I thought that I would try to break it down for you today as much as I can. There are ways to get your green card without marriage. But here's what you need to know. You have to qualify in some way for that way. And there's also over 20 ways, more than 20 ways. But the last I checked, I counted over 20 ways to get your green card. And just one of those ways is based on marriage, based on being petitioned by a spouse. So, can you imagine how many other ways there are to get the green card? I'll break it down into three categories, right? So, the first is through employment, and there are different ways to get it through employment. The other is family based, and there are different categories within the family based. There is through business, and there are multiple ways to get it through business, and then there is through humanitarian ways. There are multiple ways to get it through humanitarian ways, and then there's a fourth. There is through the diversity lottery, but that's designated for specific countries. So those are four main categories that are there with subcategories where there are opportunities to get the green card. So to answer your question, simply yes, you can. But do you qualify for this? And while this, I can go on and on. This could be a whole conference. This could be a 5-day conference to cover all the ways. And I'm going to break them down further. But this is where it's so important to make sure you talk to an attorney, because the attorney can break down those ways for you. Now, I am focused, when I am in my consultations, I focus on detail. And so I find some people may be frustrated when they call attorneys because attorneys will ask one thing. Most immigration attorneys will ask one thing. Are you married to a citizen? If you're not, and you don't have a very common outright way to get the green card, they'll be like, so sorry, go find a spouse. When you find a spouse, come back and we'll talk about it. Right. But in my consultations, I ask questions to determine whether you can fall within any of these other categories. Now, and if there are alternatives, if you don't qualify for the green card through family or straight out through an employer, are there other alternatives that can lead you to eventually get the green card? And that's what has helped me to help clients who did not think they had any chance at getting residence here, is that I focus on details. And while I'm asking questions, I'm trying to evaluate whether they fall into any one of these subcategories of the major four categories. Now, let's talk about employment, right? So, employment, you're not married, you're here, you're trying to figure out how to get your way to the green card. Now, if you're out of status, keep in mind they're very strict with employment based green cards. You cannot get your green card if you're out of status here. So if an employer is looking to sponsor you, or you would like to then adjust status to an employment based green card in some way, do not overstay your visa, because you will not end up with your green card. You'll end up overstaying and being stuck here. So if any employer, and this is a warning for you, if any employer is telling you, work for me first, do what you have to do for me first, and then I'll go ahead and sponsor you for your green card, do not trust that employer. because they're not telling the truth here. If you're working without status for that employer, there's nothing they can do for you. Now you're working without a permit, you're barred from adjusting status to green card here in the US. If you are overstayed, they will not allow you to adjust status. So that's one thing. So the employment-based green cards are mainly for those who have status, right? Who already have status, or there's a loophole there that allows them to adjust status through employment. So, for example, some DACA recipients are able to still go through the adjustment of status, or go through, if they can't stay here, they can go through an I-601A waiver process to get employment based green card. TPS holders may have some loopholes to be able to adjust status here in the US, but for the most part, if you don't have an official status where you say you have an H-1B or you have an H-2B, then it's unlike, and you're out of status, it's unlikely that you're going to be able to do that employment base. Now, there are different ways, different options to pursue employment base. An employer can sponsor you, or you may be able to sponsor your green card for yourself, right? Through the extraordinary ability green card. So with the extraordinary ability green card, you don't necessarily have to be famous, but what in the area that you're working in, you do have to show that you have reached the very top of your field, and that you're very good at what you do. So the number one thing there, and there are different criteria, so that you have to meet 3 out of 10 criteria that you have to meet to show that you've reached the top of your field, right? Do you have articles? Do you have groundbreaking research? Do you have publications? Are there publications released about you? Do you have a higher salary than the norm because of your level in whatever field you're working in? Do you have you ever gotten any awards, international or national awards, based on the field that you're in? That's the level of detail they want with the extraordinary ability green card. The national interest waiver, that's where you can petition for yourself. It's similar, except it doesn't go as high as the extraordinary ability. So the national interest waiver says you can sponsor yourself. Of course, if you're going to do adjustment of status here in the US, you still have to make sure that you maintain your status and you do not work without a permit here, right? So if you're here, say you have an H-1B, or you have another type, say you have an O-1 visa, or you have another type of visa that's allowing you to stay here, then you can possibly do the adjustment of status process. Now, with the national interest waiver, you have to show that you have an advanced degree, and the advanced degree is going to be master's or PhD. Or if you don't have that master's or PhD, do you have a bachelor's degree and then 5 solid years of experience in the field related to the field that you're working in? If you can show this, then automatically you can get to the next stage in the national interest waiver process, where they're going to look at what are your goals coming here. Do you have an important goal here? Do you have the means to achieve that goal, and is it going to benefit the United States? To waive an extra step you have to take in the process, a labor certification, that means they'll waive the requirement that an employer has to do it for you. Are they going to benefit from that more than just making you go through that process? Right. So in a nutshell, those are the criteria. That's the criteria that they look at once you've reached that stage where you have to show your advanced degree. Now, if you don't have your advanced degree or the 5 years of experience related to your bachelor's, you can still show exceptional ability. And they have you have to show that you have at least 3 of 6 criteria to meet the exceptional ability goal. So, do you have 10 years of experience that you can show? Have you received awards or some sort of recognition for the work that you do? Do you have a higher than normal salary in your field? Are you licensed in the field that you work in? Do you have a degree or some degree that's related to your field? So those are some of the requirements that they want. Do you have publications? Do you have publications for you, written by you or about you, and the work that you do? If you can show 3 of the 6 of the criteria, then you can show that you have exceptional ability. And then the next thing they want to know is, are you going to achieve a goal here that's going to be beneficial to the United States? It's going to be of substantial merit and national importance. Do you have the means to achieve it? So, do you have the experience? Do you have the contacts? Do you have a business plan in place? Do you have the actual ability to achieve whatever goal? So, for example, you're coming here to start a business, or you're coming here to do important research. Is it going to be of substantial merit and national importance in the US, the kind of research you're doing? Do you have the means to conduct the research or create the business that's going to be beneficial to the United States? And is it going to be beneficial to waive the extra step that you have to take, that labor certification process and the process of showing you have an employer who's sponsoring you is it going to be beneficial for the US to waive that requirement? Now, that is one of them. So it's national interest waiver or the extraordinary ability. Those are the 2 areas where you can petition for yourself. With the others, you are required to have an employer do it for you, and it's going to be dependent on your level of experience, your education, and remember, there are categories for skilled labor, unskilled labor. With the skilled labor, you do have to show that you are qualified for the specific job that you're going to work for, and that they need you on a permanent basis. And the employer has to first submit the labor certification. But all of that can be done without getting married. And then keep in mind, there are also waivers to the labor certification. For example, nurses. So right now, they are waiving labor certification for nurses. So if you are a nurse in your country, you want to come here to work, and a hospital has offered you a position, as long as the hospital agrees, they can file that petition for you and have the labor certification waived. So it's a much easier, straightforward process where if you're here, you are maintaining status, you could then adjust status here. Or if you're outside of the US, you'd have to go through consular processing. So those are the employment-based categories. And I would just say here, if you're thinking about getting the green card, you're already here and you don't have your status, then it's very unlikely that this category is going to work here for you. There are exceptions, right? So I mentioned DACA and TPS under certain circumstances. For example, if you're here and you're here out of status, you have a US citizen or a legal permanent resident, spouse, or parent who will experience extreme hardship if you don't get the green card. Then what will happen is the employer can petition for you. Upon approval of the petition, you would have to get a waiver based on these relatives. So if you have these relatives present here, you could go through that waiver process. And then you would still have to go to the embassy, though, in your country to finish out the green card process. You'd have to travel to the embassy right before your interview. So it doesn't allow you to stay here and get the green card, but it is a way where if you don't have any other options, you're not married, that you could still get it. So if you're not married, you can still depend on the extreme hardship of your citizen or resident parent. So that's an exception to that rule, that general rule that if you're out of status, you can't get the green card through employment. Um, and then also remember that this is general information, and a solution is going to be highly dependent on your particular circumstances. Now let's talk about family based. So chances are, if you're asking, I know if you're asking, can I get the green card without marriage? Chances are you don't have any family members who can get you an green card fast. And you have been told that the fastest way to the green card is through marriage to a U.S. citizen. That's usually where the question is coming from. However, just so we can run through quickly, I want to tell you about the family-based processes so you're fully aware. Now, if you're under 21 and you have a parent, or you have a parent, then that citizen parent who is a citizen or a permanent resident, they can apply for you. And right now, it's still a faster process than other processes. So if you're under 21, then you still have a chance at getting through the process faster than other people. If you're outside of the country, it's 2 years. If you're in the country, it could be 3 years. It could be 2 years. But if you're the child under 21 of a permanent resident, you cannot be out of status. If you're out of status, you will then have to do a waiver and go back to the embassy. So there are still some things that you'd have to work out if you're out of status. But the important thing you should know is, if you have a child, or you are listening to this right now and you're under 21, whether you're out of status or not, get on it, because you are in a category where it's still faster than other processes, regardless of if your parent is a citizen or a resident. Right now, they're going on the same timeline. So I urge you to make sure you get the assistance you need to confirm you qualify and move forward with your process. Because once you get to age 21, once you hit 21, that opportunity to have a faster process goes away. If you are out of status, though, and you are 21 or over, it's a 5 to 7 year process. It doesn't matter if you have a citizen parent, doesn't matter if you have a resident parent, it's going to be a 5 to 7 year process. And in that case, it is a path to a green card, but obviously it's not very fast. My advice here for you, though, would be, go ahead and have your parent. I know it's 5 to 7 years, but always get legal advice, because when I'm saying this, I'm saying this generally. But I advise that the parent still file an I-130 petition, because that I-130 petition is creating an option for you in the future. So if nothing else ever comes up where you can qualify for a green card, at least 5 to 7 years from now, you can look back at this option and it will be there for you to pursue. Or if you get a petition in and somehow we have positive immigration reform that then allows your process to be sped up, because they're trying to be more compassionate about family members who are trying to stay with parents, citizen or resident parents, then you would be in line to benefit from whatever changes will happen in the law. So I usually say it doesn't hurt to create that option for yourself in the future. And I say this because I've learned from my clients and what I see them go through. For example, people will come to me and they will tell me they came to the US they 7 years ago, and thinking about having parents, decided not to, because it's such a long time. But now here we are 7 years later, with them trying to figure out an option, right? And had they filed that, they would have had that option today, right? So that's a potential option for yourself in the future, but always get legal advice before you make any moves. And this is what I'm here for. I'm here to assist you with your options. Now, so those are paths to green cards, ways to get green cards without marriage. That's what I'm talking about here. And so I'm talking about other ways to get it through other family members, not through a spouse. Now, if you're the parent of a citizen who's age 21 and over, you can qualify for the green card. Now, if you're outside of the US or in the US, you can qualify for your green card. Now, what if your child is not, what if they treat you badly? And that's the reason they haven't filed for you yet. They reached 21, maybe they're refusing to apply for you, along with um, treating you badly. Treating you badly could be using the fact that that you're not able to do things as freely because of your status, so they hang that over your head. Maybe they have substance abuse problems themselves that lead them to lash out at you. You can apply for your own green card. And one of the things that a concern, of course, of any parent is, if I file this, am I going to get my child into trouble? And this is extremely confidential. They will not release this information to your 21-year-old citizen child. But this is not here to get anybody in trouble. It's not there to call law enforcement on your child. It's there to enable you to empower yourself. So they don't share information outside of the agency, and they only look at the evidence before them, which the evidence can be your statement. They look at the evidence before them to determine whether you need it. And I often bring up this point. It's there to empower you so you can do better as a parent yourself, where this child cannot use your status against you, use your immigration status against you. So if your 21-year old or older child is mistreating you, if you're living with them and they're adults, they're over 21, you're living with them or lived with them and they mistreated you, and that's why you had to leave their home, you qualify for VAWA here. So it's not just for the spousal relationship, it's also for the family relationships as well. So your 21-year-old or older child can sponsor you, or if you're being mistreated by them, you can basically sponsor yourself through the VAWA process, which I work with clients on. Now you have the green card for siblings, or citizens can sponsor their siblings, but it's 14 years. It's a very long process, but it's there, and I'm just mentioning it there because it is another option. If you're outside of the country and you're willing to wait 14 years, maybe you love where you are right now, but you want to create that option for yourself 14 years from now. Maybe you're in your country and you're going about life, but you are looking forward to possible retirement in the future. Your sibling could sponsor you, and 14 years from now, you could buy your retirement home here in the US and have your green card. So, that it can be an option for you if you're planning in the long term. And it's 14 years in the Caribbean. In Mexico, it's over 20 years. So a very, very long time, but nevertheless, it's an option here. Now, when I'm evaluating whether there are options for clients, especially now when clients want an option right now, they don't want 14 years from now, I do ask about their relationships, right? So this is how to get a green card without marriage. But there are situations where without marriage means that you are married, you just you can get it through the spouse that you're with. So we'll talk about that, and that's VAWA. If you are in a marriage where the spouse is refusing to get your green card and they're mistreating you, then this is an option for you where you don't. What if you're divorced? Now, what if you've already been divorced? Then you can qualify, but the clock is ticking. It has to be within 2 years. It has to be filed. Your petition has to be filed within 2 years of the divorce. So if it hits 2 years, you're done. Another thing is, what if your spouse passes away? You have 2 years after the death to apply. What if your spouse got deported and lost their status? What if they were what if they were permanent residents and they got deported? You have 2 years after they were deported to apply for this. Yes, you can still qualify for without the marriage. You can still qualify in death, in divorce, in they lost their status. You can still qualify for the green card if there was mistreatment in the marriage. So keep those in mind. Now, what if you are the child of a citizen? If you're under 21, citizen or resident, not just a citizen, and same with the VAWA. If you are the spouse of a citizen or resident, or you're divorced from a citizen or resident, the citizen or resident passed away, you can qualify for VAWA relief still. Okay. And then if your citizen spouse passed away, but there was no mistreatment, but they just passed away, you can apply for yourself as a widow, right? But you have 2 years to do it. So keep those exceptions in mind that even if there was some sort of marriage involved, but now it's over because of death, because of divorce, because maybe separation, you can still move forward without the marriage, but that's where you have limited time to apply for the relief. The relief is there. Now, if you're the child of a U.S. citizen, U.S. citizen or resident, if you're the child of a U.S. citizen or resident, you can apply for a green card on your own if that parent mistreated you. The clock is ticking here because usually you have to be under 21. But if, say, you are already over 21, you can still apply for this relief as long as you haven't gotten to 25. So if you're under 25, we'll look at your circumstances to see what caused the delay. Because what happens is when we have cases like this where clients they were mistreated while they were under 18, they were children when they were under 21, but they never applied. And it's because they didn't know it existed and they were in the middle of being mistreated by the parent. The parent was controlling their movements, the parent was controlling the kind of information they got. The parent was promising to apply for them the whole time, or the parent was perpetuating a fraud saying they've applied for them. And so they didn't apply for themselves. They didn't have the ability to apply for themselves because maybe the parent controlled their finances, where they lived, and they're busy trying to survive those years with the parent. In that case, we can then show that the mistreatment by the parent was related to the delay in applying. That's how we get past the deadline that says you usually have to apply as a child of a citizen or resident who was mistreated. So through VAWA, if you're applying through VAWA as a child and you never got to it until you were 24, we look at those circumstances. Now, in everything here, you say you don't have a parent, you don't have, or you have a parent, but it's going to take 5 to 7 years. You don't have, or you don't have any other pathway, right? So say you for some reason you can't apply for status right now, but after I've asked you questions, it has been revealed to me that you experience circumstances that can qualify you for other relief. Then we explore those options. Now, the other relief I'm talking about is humanitarian relief. Now, one is asylum, right? Asylum, though, you must make sure that as soon as you enter the United States, you evaluate your options for asylum. Do you qualify for asylum? Because once it gets to 365 days after you've entered the country and you did not apply for asylum, it gets exceedingly difficult to apply for asylum. And I do know individuals who have consulted with me, but they've consulted with me after the fact. There were no extraordinary circumstances that caused a delay in them applying for asylum. And so it no longer is an option. Because the only way you can get past the deadline is to say, well, you experience some kind of circumstance that caused an extraordinary circumstance that caused the delay. So maybe you were, if God forbid, but say you were hospitalized for a very long time while you were in the country and you missed the deadline. It, something of that nature where it was out of your control to apply can then get you past the deadline. Otherwise, it's very difficult to justify why you were late on filing for the asylum. So if you've come through the border or you are here now and you're trying to figure out, how to settle here, you're going to need to make sure you understand that you have a deadline, that you can't apply for asylum 10 years after the fact unless you can justify why you're applying 10 years after the fact. Now, asylum, you first get asylum. And then after you get asylum, you have a path to permanent residence. So it's not asylum, you don't get asylum, then the green card right away. You go to asylum, then you have to show that you've been in the country continuously for a year and you're able to then apply for permanent residence. But after that, then you can go on to US citizenship. So it is a path to permanent residence. Now, the other is the T status. This is relief that is overlooked by not only clients or individuals out there, but people, professionals like me who do this every day. Because it's the T visa is for victims of trafficking, and we all, before I started to practice immigration law, even I myself had a very limited perspective on what trafficking was. When I thought about trafficking, I thought it was sex trafficking. I thought it was somebody being kidnapped and being held hostage or prisoner somewhere and being forced to do sex acts against their will. However, trafficking is the definition of trafficking under the law is much broader than that. And immigration, they have updated the immigration policies to be in line with this broad definition. You would be surprised at how many people are experiencing trafficking. And it's sad because the reason that the people are experiencing this is because the very same immigration laws that are there that are there to the broken immigration laws are there to tell people how to get their status is also causing a lot of employers, a lot of intimate partners, a lot of strangers and acquaintances to take advantage of immigrants here in the US by using that, abusing the law to keep people hostage. Because trafficking isn't just about physical restraints, it's about mental restraints. One area that I find is very common for trafficking is the hospitality industry, and also the group home industry, where people they own these small homes where they take care of elderly people, they take care of disabled individuals, and they lure foreign people to come to the United States under the guise that they're going to get them a work permit, or they're going to they're going to give them all these great things. If they don't even promise them a work permit, they promise them that their work conditions are going to be great. They're going to have maybe one or two patients that they have to look after. They're going to have their food and housing taken care of. And they're going to work Mondays through Fridays for or 3 days a week for 12 3 12-hour shifts. And that's going to be how it's going to be. Really, they make it look all rosy. And then when they come here, they are abused, they're mistreated, they're underpaid, they're overworked, they find themselves working 24/7. They find themselves under threat of being sent home, or find themselves under threat of even violence, or the employer will tell them that they're going to call ICE. Or even if they don't use those outright threatening tactics, they will go ahead and tell them things like scare them. There's nowhere else that's safe for you. It's only here that's safe. If you go anywhere else, you're not going to find any better opportunities. Where are you going to go? These are all abusive tactics used to keep individuals where they are, keep them prisoner, but it's a type of mental restraint that keeps individuals where they are and keeps them subject to this abuse, this overwork, right? They know the person, the immigrant, doesn't want to be there, but they feel like they're stuck. They can't go anywhere else, and so they continue. They're afraid to leave. This is happening on it is really a pervasive problem, and the employers are taking advantage of the fact that immigration is there and ICE is there to keep people restrained this way. Those are examples of trafficking cases that we have won, right? Where these scenarios we have won it. Now, another is where you are being held that way by a partner. It doesn't have to be an employer. Suppose it's an intimate partner. Sometimes a common thing that I find is they use the promise of marriage. Come stay with me. I'm going to marry you. It's going to be as easy as me marrying you. You get your papers. We live happily ever after. Then you get into a situation where they don't do any of what they promised. They have you in their home. You're either taking care of their children, you're cleaning their house, you're cooking for them, you're doing all of these things that you never signed up for, but somehow you are not benefiting at all. Maybe you're working outside of the home and they're taking some of your money to keep you helpless, or they just love the fact that they can take a portion of your money from you. That is also an example of a form of trafficking done by an intimate partner. Now, another thing is that when they're doing this, they're also asking for other things for you to do, perform sex acts with them, even though you probably have reached a point where you don't want to even have a relationship with them. But now they're saying things like, where are you going to go? What you're going to do? You have to do this, right? Why do you think you're here? And you have to end up in this situation where you are performing sex acts with them, even though you don't want to, but you feel forced to, doing housework, and just being mentally, even if they're not physical, in some cases, they even get physical. That's an example of trafficking as well. Now, when we determine that you qualify for this, we can then move on to getting your status here. So when you get approved based on being the victim of trafficking, you get an updated I-94. If you have inadmissibilities, so say you cross the border without permission, say you have misrepresentation on your record, that can be forgiven in order for you to get the T status. Now, once you get approved for the T status, the general rule is that 3 years afterwards, you can apply for your green card. But there is something called early adjustment of status process where you can get it earlier than that. And what we do is we go to the Department of Justice, and we get what's called an early adjustment letter that is then used to, it's like a permission type of a permission letter for you to apply before the 3 years. So it serves as a valuable relief because the person that's doing this to you, they don't have to be a citizen, they don't have to be a resident. They themselves, the person that's doing it to you, could themselves be undocumented. So it has served as an alternative for clients that have had no other options here. Now, we've talked about asylum, the T. There's also U visa for victims of crime. And the U visa works similar as the T. Unfortunately, though, it doesn't work as quickly. So the U is backed up by 10 years. But what they're doing is they're doing deferred action. So whenever you show that, yes, you qualify by applying, then you can get deferred action while you wait those years for your U visa. And then after you get the U visa, 3 years after, you can apply for your green card. Um, so I think I've covered a lot of ground here, and for sure, there are probably things that I have not mentioned here because there's so much, right? So many ways to get the green card without getting married. But I've touched some of the major ones. There's also the diversity lottery. So every October, you can, and if your country qualifies, right, you have to look to see if your country, for example, Jamaica doesn't qualify. But if your country qualifies, you being a citizen of your country can go and sign up for the diversity lottery. And if you're selected over the next, fiscal year, you can then see if your number becomes current. And then you can be processed to get your green card and either enter the United States. And it's rare, but if you're already here and you have status, you can adjust status through diversity lottery as well. So that's a potential option, a last resort option if your country qualifies for it. And the diversity lottery, if you're out of status, this is likely something you cannot pursue, because if you're out of status, it means that you can't go back to your country to go to the embassy to attend the interview. If you do, you're going to be stuck in your country more than likely. And if you're here, you can't do adjustment of status being out of status. So it's not usually an option for those who are out of status. All right, so I'm going to take some time to answer your questions, but I thought this would be a valuable. I really sat down and gave you a spiel here because it's a common question, and I want you to know about some of those options in summary. But if you really, and thanks so much for the love, I appreciate it. But if you really would like to explore your options, give me a call, schedule your appointment, because that's where I'm going to be able to talk to you and really figure out if one of these options work for you. So Nessa, you just called the office. I really hope you had a good experience. Um, Can I withdraw the already filed application? So in some cases, and most cases, you do have the ability to withdraw, but please make sure that you check with an attorney. You can always call us, schedule a consultation to get advice about whether that's the best option for you and whether that's the right move for the type of application that you want to withdraw. Go ahead, put your questions in the comments. Now, your questions can be anything that's immigration related. So much for the love. It does not have to be just about this extensive topic that I talked about. And I know I gave you a lot of information, but I'm giving you the information. And then as soon as you want to figure out your options, you can give us a call and we can talk about your options, not all of this information. But if you can relate to something here, this is where it's very important to give us a call and schedule your appointment. All right, so I did see something. How can a C1D holders adjust without leaving the States? So now, when you do have the C1D, it's a sticky situation because you're in most cases you're barred from adjusting status. So if you have a C1D, otherwise known as a crewman's visa, Do not overstay without, understanding the consequences, because it can be severe. If you get married to a citizen, you cannot adjust with a C1D um, visa. So now, under VAWA, they are saying that they will allow the C1D visa holder to adjust status under VAWA, which is if you're being mistreated by a citizen or resident spouse, parent, or adult child. But if your spouse is going to petition for you, it's not going to work. So be very careful. If an employer wants a petition for you, it's not going to work. So be very careful about that. So, how can a pilot that wants to fly commercial for Delta, for example, get permanent residency in the United States? So, Delta is going to have to go ahead and submit the documentation for that. They're going to have to submit the labor certification as well. And then, once the labor certification goes through, they're going to then have to submit the petition. And you would submit the adjustment of status if you're here. If you're outside of the US, you're going to have to go to the embassy for the final interview. But that's an example of the basic process that's involved for an employer to petition for an employee, including pilots. I would love to talk to you, but I don't have the money to pay. Well, go ahead, give the office a call. First, it is quite an investment, but first, always go ahead, call, figure out what the cost is, and then plan accordingly. But I really do want to help you, but it's also about you making the investment, because it is an investment here. And I'm giving valuable legal advice that's going to help you in the future. So, don't count yourself out and don't think I can't afford it. Find out what it costs, and then go from there and call the office, see how we can help you. All right. Hi there. Can a lawyer or legal consultant you agree to do business with to file your adjustment of status? I'm sorry, that's a little jumbled, but I think what I'm getting from this is, can a lawyer or legal consultant you agree to do business with to file your adjustment of status? You submitted all required. I'm sorry. I'm wondering if you're saying, can they require you to submit it? So yes, it just depends on the agreement you entered with. Um, Now, and this is where it's important to just make sure you look at your retainer agreement, make sure you have an agreement in writing with the individual you're doing business, the attorney you're doing business with. And, yes, there are immigration consultants that they get permission to work and represent you before the USCIS. But there are a lot of people out there that are touting themselves as immigration consultants that they are not. They don't have the ability to give you legal advice. They don't know the law extensively, and in some cases, they get people in trouble. For example, what I have been seeing a pattern is these immigration people will say, the first thing they'll say is file for asylum. And you may not qualify for asylum. You haven't gotten a detailed legal evaluation to determine whether you qualify. And then it turns out to be a frivolous asylum claim. If it's a frivolous asylum claim, it means that you could face a lot of problems and you could find yourself before a judge. So, that though some of them encourage you to submit fraudulent applications. If they're telling you to make up a story, that can get you into a lot of problems. So don't get tied up with people that tout themselves as immigration consultants, because they will collect your money, they will fill out your forms, and then when you try to find them, when everything is going awry, you're getting a request for evidence, the immigration has questions for you and you're trying to find them now to help you with this or to give you copies of what they sent, they're nowhere to be found. So be very careful about that. Okay. So can the consultant submit the documentation without signing the paperwork? They're not supposed to. So if they prepared it on behalf of someone else, they're supposed to sign as preparer. Now my mom is frustrated. She wants to withdraw her application, collect her documents and money. So this really is an issue between your mom and the person that did the paperwork. But I'll just warn you that this is what commonly happens: is that when you're working with people that are not qualified, that you can get yourself into more hot water. Because yes, working with an attorney is more expensive and it is an investment. However, it's a it is the reason why it's the best investment is because the attorney understands how to navigate the process. They understand the legal issues involved in the process, and that means you have a smoother, faster process. But when you're paying somebody, even if an attorney is advertising saying they're just going to fill out your paperwork and give it to you to send in or send it in, and that's going to be it, they're not going to represent you on the rest of it, that ends up being a problem because when you have to answer questions, you don't know how to answer, you don't know how to approach a situation. So when I represent my clients, I do my representation is comprehensive. Me and my team are available for our clients. We're there to answer questions. We're there to respond to any questions from the USCIS, from the Immigration Court, from NVC, from the embassy. We're there to make sure that everything is going according to plan. We're there to prepare them for the interview. Where I'm there to attend the interview if necessary. But if you invest in a process where they're just filling out paperwork and they're not there for you for the hard questions that will come, or questions that will come that if you answer incorrectly turns into an ugly process, that's where everything goes bad. So, it's an investment, just like everything else, just like when we talk about making a good purchase, right? We spend the money to purchase higher quality clothes, for example, so that it lasts longer, so that we can save money in the long run because we're not constantly going out and buying clothes. It's the same thing when you're hiring an attorney. Is you're looking at the long term. You want your green card and you want it as soon as possible, then you have to make that investment to make sure you have a good, solid process. Okay, so can I travel home and adopt a baby while my VAWA case is still in process? Wow, that's that. No, that one it sounds a little complex because you have a lot going on there. So it depends on what the adoption process, because you're going through VAWA. So that means that you don't yet have your green card, but then you want to go ahead and still adopt a baby. And it is possible. But if you're traveling out of the country, you also have to keep in mind how long will you need to travel out of the US? What are the risks involved in going to complete the adoption process? Will you have to live with your baby for a long time before you can before you can formally adopt your baby? So there are some legal questions here that you'd have to answer first before you should jump into that, because the VAWA process alone can be overwhelming and it can be a complex process. But now, if you're throwing in adoption, you have to make sure that everything lines up nicely to be able to to um, to successfully get through that. When you get the T visa approval, can you use the letter to get benefits from DSS? So usually, no. Usually, when upon approval, this is the another good aspect of the T visa. Upon approval, is that you have the option. You're not forced. You have the option by the government, so the Department of Human Services. You have an option to be able to get a case manager who can help you with benefits. Whatever benefits you need to get settled to help you move forward in life. You get benefits similar to a refugee. And so when they issue the T visa approval, they also send the approval notice to the other department in government that then usually contacts me as the attorney to say, um, just know that your client, here's a certification letter, just know that your client can now also contact us to get assistance to navigate their benefits. Um, Now, usually it depends, on the state you're in and the office we're working with, but sometimes they do want a social security number along with the proof of your status, your I-94, your work permit. So it may take a few weeks, for the work permit, the social security number to come in before the case manager can take over your case to then start applying for benefits. But what I usually tell clients is take that letter and go contact the office because you still get issued a certification letter. Contact the office, get started on the application, and then once you get if the SSN is required to complete the process, once the SSN comes in, you can follow up with the case manager. So this is another benefit here is that you do have valuable access to valuable relief that helps you and your family to get settled here. All right, so I'm gonna scroll through just to see if I have some final questions here, and then I'm going to head out. I'm in my 40s and have been here 9 years. My mom is a green card holder. How long will it take? So unfortunately, it's a 5 to 7 year process. Now, this is where, though, it's important to look at the alternatives, and that's what I do in my consultations. Is I not only look at the straightforward options, but I look at what have you been through. When you've been here for a long time, you would be surprised the what immigrants who have been here for a long time have been through. And so when I hear facts that line up with labor trafficking or sex trafficking, then that is a form of relief that can get you your status and get you to permanent residence eventually faster than the 5 to 7 year process that it would take through a parent. If your child was under 21 before you filed but reached 21 before she got through, does she still get through as an under 21? It depends on, so it's called the CSPA. It's an act that was passed, a law that was passed to enable children who then turned 21 to still qualify for the green card. But there's a special formula that's used to determine whether their age can go back to under 21. So I believe they take the time, so the time between the approval of and it varies depending on the status of the parent. So, for example, if the parent is a citizen, their age freezes. They're never gonna, as long as they stay within the same process, they're never going to be treated as an adult and go into a longer category. They're gonna always stay as they were under 21, even though they get older and older year by year, their age is gonna stay at under 21 for purposes of immigration. But for children of green card holders, then they are going to take um, the time that was the petition was approved, the time between the petition was approved and an immigrant visa number became available. They're going to take that time and they're going to subtract it from the current age of the child. And at that point, when they do that, they're going to get an age. And if that age falls under 21 again, it means that they're good to go. Even if they are maybe 22 or 23, if after doing the calculation, they're they're under 21, they're good. So that's the formula that they apply here. And it depends on who's applying, what the process is going forward. Good afternoon. Is there any solution for an overage child? There are possible solutions, but it depends on what the circumstances of the child is. And this is where it's important to do the appointment. Now, let me tell you how to get in touch. Go to the link in the profile. When you click on the link in the profile on Instagram and here on YouTube, on Facebook, on Twitch, go into the description of the video. You'll see the link. There's a link that says schedule your own appointment. Go ahead, schedule. Get on my schedule now so we can start talking. And my schedule is filling up, so you want to make sure you're on it. Now, if you don't want to do that first, you want to call the office, kind of ask questions about scheduling or get help to schedule, call the office. The number is also in the description of the video and it's also at the link. If you go to the website, and it's at the link in the profile, you'll access all of that. What about LLC owners that are not living in the US? So being an LLC owner alone isn't going to qualify you, but if your business is doing really well and you can show that you're an exceptional business person, or you're a business person with extraordinary ability, then or you have invested more than $900,000 into your business, then this could business in the US, it could qualify you for different types of green cards. So that's another category, and it's the category of getting the green card as a through investment, and that's going to be if you invest over 900,000, 500,000, if it's a designated type of business, but if it's a personal private business, it's 900,000. So if you're out of status and your J1 is approved, what can you do next? So I'm not sure if you're out of status, how your J1 got approved. I don't know if that's a waiver. The getting the waiver isn't going to do anything, but it does allow you to change status. But if you're out of status, it could present another issue. So it was a change from H2B to F1. So, give me a call. Let's talk about your options. Um, what route can a H2B visa holder take to get a work permit to remain in the States? So the work permit has to be granted through qualifying through one of these ways I listed. So this whole live was about that. So I need to talk to you about what your circumstances are, and see if you qualify for something. All right. I couldn't get to all the questions today. I have to head out, but I will be back tomorrow. So save your questions for tomorrow, and I'll get to them and come with a topic that we all can relate to. All right. Thanks so much for your time, everyone. I'll see you tomorrow. Bye bye.